Good morning, Mr. Keegan.
Good morning, Chief Justice Island. May it please the Court. I'm Robert Keegan, appearing with Cheryl Kimball, my partner, on behalf of Bay State Gas Company, the appellant in this proceeding. This is a case where the Department of Public Utilities failed to apply the required standard when it denied reasonable operating costs in a Section 94, Chapter 164, Section 94 rate case. This Court has continually found that utilities are entitled to recover operating expenses unless there's a finding that those expenses are either excessive, unwarranted, unreasonable, or incurred in bad faith.
Mr. Keegan, can I just ask you this question?
Yes.
If, which I know you say didn't happen and apparently didn't, if in the 2008 divestiture proceeding, the DPU had said what you say that they in effect said in this decision, that they said right there, you need to hold harmless the Massachusetts ratepayers from any additional costs that are a consequence of this divestiture. So we get here, you file your rate case in 2009, and the DPU says, no, you can't get this $1.9 million because that directly comes from the divestiture, and what we said there was you have to hold them harmless. What would happen?
Well, first of all, they would have to say that in the case that they did.
No, I understand. Let's just assume that they did for a minute.
Were they to determine that there was harm, and I just have to say, these are not increased costs, and I don't see how any finding of harm can exist in having ratepayers pay costs that are necessary and reasonable to provide them with service. But assuming that they did reach that conclusion, I would say first, the company would have to take a look at the basis for that finding, and with that notice, make a determination as to whether they appeal that case to this court or decide not to go forward with the merger itself. There's a notice issue. And I think, frankly, that case would be in front of you because of finding that costs, even though they're necessary and reasonable to provide service, can be disallowed from rates on the basis of some arbitrary or vague notion of what's equitable or what customers can afford is not the basis for establishing rates.
But if the equitable finding is not what customers can afford, but because you chose to divest when you chose to divest, totally because of your, not because of the ratepayers, but because of your bottom line for your investors, that's your decision, but we're going to tell you that you're not going to charge our ratepayers for that. Why would that be improper?
Well, they could reach that, I suppose they could reach that conclusion if, after looking at all of the myriad of impacts in 9 different areas that they do look at, that they made that decision. Tell the company that they're going to do that and let the company make a decision as to whether or not to move forward with the merger.
But at least Mr. Guberman says, no, they didn't say that, but they did say we're going to deal with this issue in the next rate case.
I disagree that that's either what the company argued below in that case or what the department found. What the company argued most of the brief in the merger case was that the department didn't have jurisdiction to determine whether or not the merger should go forward because Northern Utilities was a New Hampshire company, all of the assets were in New Hampshire, and none of the facilities were jurisdictional to Massachusetts. But the company argued that, be that as it may, ratepayers are well protected because the department has, under Section 94, the ability to ensure that only reasonable and necessary costs associated with providing those ratepayers with service are in fact going to be charged to them. That's the protection that the department has. And so what did the department do? The department said, we will look at the rate-making treatment, not the rate impact, the rate-making treatment to be applied to those costs. That's protecting customers so that if in fact there were costs left over, that because Northern was no longer supporting those costs, they had to go on the rates for the remaining body of ratepayers, the department could look at those costs and say, is that really right? Or are these costs excessive and not really being incurred to provide Bay State customers with service? That's what the department had the ability to do, but they ignored all of the substantial evidence that the company presented on that record.
So let's go back in time again. It's a question similar to Justice Botsford's. Let's assume in the 2008 proceeding, Bay State said, here's what we plan to do. There won't be any adverse impacts, except we are going to ask for a $1.97 million rate increase because we estimate that it's just going to cost us more for our ratepayers if we don't have this. What would DPU do with that? Would that be a basis upon them saying, no, we're not going to permit that rate increase because this was a transaction you engaged in for the benefit of your investors, not for the ratepayers? I mean, what could they have done at that point?
Well, they would have had to find that on the overall standard, looking at all of the impacts, that there was net harm. Now, it was clear one of the impacts they did look at was, what's the rate impact associated with the sale of Northern? And I disagree. The reasons for the sale of Northern, the record does not support it, was just for shareholders. The company had a lot of evidence out there that continuing to provide Northern was in fact becoming a drain on the company. And for example, they were going to have to start increasing the capacity of their call center. All right. So
So if Bay State had come in and said, we also want, because this disposition is also going to end up costing money to our ratepayers because we're now going to have to pay these expenses ourselves, and we want a $1.97 million increase, what could DPU have done at that point?
Well, I'll tell you what the DPU did do when they looked at what the potential rate impacts were. They looked at the potential for, under a worst-case scenario, absent any mitigation of costs, rates to be impacted by $5.14 million for Bay State Gas Company. They also looked at the fact that because Northern...
I thought your client said that would be de minimis and not to worry about that.
That the client, on that part of the case where the department was looking at the impact of that amount on the financial integrity of the company identified the fact that 5.14 would not undermine the financial integrity of the company because it was only equal to 1% of the company's total annual revenues. But let me go back. The department, in looking at the overall impact, also looked at the fact that Northern moving over to Unitil was, in fact, going to pick up a lot of the shared costs of Unitil, and that the Unitil customers would benefit by $5.6 million. So there was a valid determination by the department in looking at the overall impact, just on the rate issue, that there were countervailing benefits to Unitil customers offsetting.
So what you're telling me is DPU would have had to have approved the $1.97 million rate increase. You said they had to approve it now. They would have had to approve it even if you had raised it as part of this disposition proceeding.
Well, I suppose that they could have looked at the $1.96 million and written an order based on substantial evidence and reasonable findings of fact that that represented net harm. And therefore, they would not allow the company to go forward with the merger unless customers were insulated from that amount. They could have made that decision.
Let me ask you this. Under Section 96, one of the considerations that may be used by DPU as to whether to approve the sale is proposed rate changes, if any, correct?
Yes.
Okay. Now, what if, well, and indeed, according to the findings of the DPU, it says, we note at the outset that neither Bay State nor Unitil proposes any rate changes as a result of the proposed Northern stock sale.
That's correct.
Correct? What if you have a company which seeks approval of a merger or sale and says, I know you're supposed to consider proposed rate changes. Don't worry about that. There will be no proposed rate changes. We don't intend to do it. And in reliance upon that, or if they say in the alternative, you will be able to evaluate the appropriateness of that because we have to come back to you for any approval of rate change, which sounds like what you did. But and they say, okay, well, they've said there are going to be no proposed rate changes, or they said we will be able to determine whether there are any proposed rate changes, so we're going to approve it. And then you come back 4 months later and say, oh, well, we actually now going to propose a rate change in part as a result of this sale or merger. I mean, they can't say, wait, we approve this in part in reliance on the fact that you had said you had proposed none at this time, and you said we could determine whether or not to approve it later on, and now you say, no, you can't do that. You now have to take our cost as fixed and view them only as to whether they're clearly excessive, which they're not.
I understand the question. That's really a misrepresentation of what the company represented in the merger case. What the company said, because many merger cases come to the department with a rate plan that's already designed to handle those costs. But in this particular merger, there was no rate plan proposed because Unitil said, we're not going to charge any of our customers for the integration costs or the transaction costs for achieving the merger. And so for the Unitil customers, it looked like they would get a benefit of up to $5.6 million. Bay State came in and said, we're not proposing any changes at this time as a part of the merger. But that's not a statement. And frankly, I think the company clearly indicated that it would, in fact, was examining the possibility of filing a rate case and would file a rate case in 2005. If you look at page 32 on the merger order, the department states clearly the Attorney General has indicated the company's intent to file a rate case in 2009. During the pendency of this case, because of the decoupling order at the department, the company indicated that it was looking at filing a rate case in 2009. And frankly, since 2005, when the company's rate plan was implemented, it had come to the department on 2 separate occasions, indicating that its finances were in difficult position and it looked for rate relief. It was unsuccessful in both of those cases, and the department was well aware that the financial pressure was going, in fact, to lead the company to file a rate case in 2009. And I really feel it's a misrepresentation to indicate that the department did not have any rational basis to understand that that 2009 rate case would be filed.
Well, of course, the commission found on page 51, Bay State is subject to a 10-year PBR plan, and its rates cannot change without department approval.
That's true under that particular rate plan. But the precedent from the department is clear that the existence of a rate plan does not preclude the company from asserting its right under Section 94 of filing a rate case at any time, regardless of the rate plan. The rate plan is an agreement where the company gets annual rate increases under certain circumstances, and there's an earnings sharing kind of arrangement in that. But if, in fact, the company believes that it can support the need for a rate case based on the return that it's earning, the department has agreed in numerous cases cited in the briefs and in the record appendix that those companies can, in fact, avail themselves of the statutory right under Section 94 to file that rate case.
But you're saying that under Section 94 they're precluded from looking at the issues that were proper under the Section 96 divestiture. Is that what you're saying now?
Not precluded from looking at the issues. They can certainly. What did they say to the company out of the 96? They said, look, we know that there are potential rate impacts. We require you in your next rate case to demonstrate what measures you've undertaken to mitigate the impact of those costs.
And that's the only thing this meant when you said in your reply brief, the law is clear when the department declines to exercise authority over potential rate or service in a Section 96, it does not divest itself of ability to review those same issues in a later Section 94 proceeding?
Review those issues in the context of the standard in 94. And that is, what are the reasonable costs associated with providing customers with service? That's what they needed to review. And I think the department, the company demonstrated through the concentric study that the $1.96 million that was excluded was in fact necessary to provide service to customers.
So you are saying that once you get to Section 94, it's a reasonableness of the cost from the company's point of view, and you leave the realm of no net loss to customers. Forget them.
and the ratepayer's point of view. The standard under 94 is the most basic principle in setting rates. The U.S. Supreme Court, as well as this court, has recognized that these are capital-intensive businesses that must have access to
I
money in the
understand
financial
the Section
market.
94 argument. I guess what this particular case raises is it the DPU should have known better not to accept you at your word, or because you weren't doing anything wrong, you utilized the available mechanisms to get out of one scheme and use another one, and you could go and ask for a change, even if you said you probably weren't going to. There's nothing wrong with that. That's one way to look at this, and that would be a win for you. The other way to look at it is, well, actually, some of these other considerations, these issues, if that's what we decide that meant, these issues are appropriate to be considered in Section 94 in this kind of context.
Not in the context of no net harm, frankly. The 96 case is a one-off case. Once they've balanced all of those variable impacts and made the determination that there's no net harm, that case is over. Now, they can put conditions in there that apply to the merger, and the one condition they put in was show what you've done to mitigate. If the department is, I just have to say, if the department is allowed to disallow necessary and reasonable operating costs to provide service to customers, that will totally undermine the financial integrity of these companies and deny them access to capital markets. That cannot be sustained as a reasonable basis for denying necessary operating costs.
All right. Thank you, Counsel.
Thank you very much, Chief Justice.
Mr. Chief Justice Ireland, and may it please the Court, Assistant Attorney General David A. Guberman for the Department.
So what do you say about that last comment from Mr. Keegan, that to do what you ask us to do is going to undermine the most fundamental principle of rate setting and essentially affect the capital markets, the ability to borrow in the capital markets? Is that what you want?
That's not what we want. That's not the consequence that we think will happen, and it's certainly not an argument that has been made with any supporting authority or facts or expertise on behalf of Bay State.
You'll admit that it's a fundamental principle of rate setting under Section 94.
It is. But there's a mistaken assumption that runs through Bay State's argument here this morning and through its briefs both here and to the Department. Bay State assumes that it reasonably and prudently incurred the costs that it wants to pass on to its Massachusetts customers. But Bay State had the burden of proof on this issue. Now, Bay State this morning and in its reply brief, but not so far as I can tell before its reply brief, comes out and says that in the absence of a finding by the Department that these were not reasonably and prudently incurred, then the Department was not free to deny the rate increases. But that's not the law. The Court has said, for example, in the Fitchburg Gas and Electric case, there are many of them. This one is 395 Mass. And the page site I'm quoting from is at 847. First of all, because the petitioners could proceed with the proposed financings only in amounts determined by the Department to be reasonably necessary, they had the burden of presenting in support of their applications evidence sufficient to enable the Department to make those essential determinations. So the burden was on Bay State to present evidence, and not simply to present evidence, but to present a coherent analysis and argument to the Department. In another case involving Fitchburg,
To present evidence that what? That these costs were reasonably incurred?
That's correct. I'm responding to the argument made in the reply brief and this morning, and I'm so far resting on the other arguments in my brief because they're expressed in the brief. In You have a question, Justice Botsford?
No, finish what you're
Okay. In the Fitchburg case reported at 375 Mass 571 at page 582, after the court suggests that the department's findings could have been more thorough, the court goes on to say, but the company was required to prove its case before the department by presenting a clear and reasonable analysis. So let's look at what Bay State did before the department. Because if they fail to carry their burden of proof, then the court need not address the other important and interesting questions, some of which were addressed during my brother's argument. Before the department, all that they did was to say that the reasonableness and prudence of incurring these costs is unchallenged. But they didn't give a clear and reasonable analysis or make any effort to explain why they were reasonable and prudent.
Let me ask you this. I mean, I'm not going to remember all of them, but some of the costs that are included within that 1.9 million are a call center. I think there was some accounting costs. Let's just take those as examples. Now, are you saying you're not disagreeing that having a customer call center is reasonable and necessary for a public utility, are you?
Not at all, Your Honor.
Or that accounting functions don't need to be don't need to happen, right?
Of course not, Your Honor.
So what did they need to do then about
All right.
that?
I'd like to answer that question directly and then discuss what may be the single largest cost item, which requires a different sort of analysis,
Okay.
and that's the leases. According to the concentric study, which is what they rely on, the concentric was given the following scope of work. Go to these different cost centers. Find out how much can be saved or mitigated or avoided now that we will no longer be dealing with Northern. And that's the end of the work assignment. What they weren't asked to do was to address the question, because then they assume that whatever is left is reasonably and prudently incurred, but they don't address the question, is there a more cost-effective way of providing the equivalent or even a better quality of service than what is left after you remove these items? So there might have been, we don't know because there wasn't evidence or an analysis presented by Bay State below, but it is possible that Bay State could have organized its affairs differently and less expensively. And this is important because when they organized their affairs, they did it knowing that they owned Northern, and they were sharing expenses with Northern. When they come to decide to sell Northern, it's not sufficient, we submit, for them to simply say, well, now we're going to figure out what we can save because we're not going to be providing services to Northern. The question that at some point needs to be addressed is when we look at how our delivery of service is going to be configured with Northern out of the picture, what's a reasonable and prudent way of doing it? Now, the best example of this, perhaps, has to do with the rents that they formally got from Northern and that come to, I believe, the
Point something or another?
$678,580. So more than a third of the total rent increase that they sought. And the concentric study is not helpful at all on this point because all that the study says is basically, well, we went and we talked to them and they're still going to need the space. Or they're not going to be able to get rid of the space. But there's no analysis or anything. And so here's the point. When a company either leases space on a long-term basis or buys a building, so it's a fixed cost, it has to be reasonably and prudently incurred in order to come into the rate base. When they entered into these long-term commitments and they owned Northern, because Northern was treated as a below-the-line subsidiary, they never had to present to the department for review under this standard the portion of the costs that were attributable to Northern. Those were the concern of the public utility commissions in New Hampshire and Maine, where Northern was doing business and where Northern had to justify its rates.
On that point, you mentioned that Northern was a below-the-line asset that,
Yes.
For Bay State. But obviously, above the line are the rents and the payments that Bay State that Northern is making to Bay State while they were jointly owned, right?
Now, my understanding is that all takes place, as they call it, below the line, so that Bay State's Massachusetts customers are not affected by any gains or losses that.
But I guess I thought fundamental to this was that when they were jointly owned, that there was in substance, Northern paid annually to Bay State for a variety of things, 2-point-something million, right?
More than that, I think, but yes, Your Honor.
Okay. And that when they split up, that 2.7 million was helping to mean that these costs that it is now seeking didn't have to be presented to the DPU as reasonable necessary costs of Bay State because they were taken care of by Northern. Do I have that wrong?
My understanding from my client is that during the time that Bay State owned Northern, Bay State, when it was looking for rates for its Massachusetts customers, did not present to the department for review and approval the expense items that involved Northern. And that is the problem.
So they, for example, they didn't present lease costs, they didn't present call center costs, they didn't present whatever these accounts.
Well, I believe that they would have had to present, let me back up. As I understand it, they had an allocation formula as between Bay State and Northern to determine what would be charged to Northern and what Bay State would bear itself. And Bay State would have had to present to the department whatever its allocable share was. The problem when you come to something like a building, which is a clearer example, but the same analysis really does apply to the labor expenses as well. The problem with the building is, let's say, and this is simply an illustration, it's not something from the record. Let's say you have a building that's 15,000 square feet, and 10,000 is being used for Bay State, and that cost is presented to the department for review, and 5,000 square feet is being used for Northern's purposes, and that's not being presented to the department for review because that's below the line. And now Bay State sells Northern, and it has a building with 15,000 square feet, and it has to pay for the other 5,000 square feet. So concentric study tells it, well, you can't mitigate that cost. And Bay State assumes that that means that the entire building cost is reasonably and prudently incurred. But it's not at all necessarily the case.
So your point is, once the split happens, it's like it's a new day, and you can't sort of take that cost as a given and then show your savings. You have to sort of prove these costs for the first time.
Exactly, Your Honor. At some point in time, costs have to be demonstrated to be reasonable and prudently incurred.
But the problem you have is that's not what the DPU found. The DPU didn't say these costs were unreasonable. They said it was inequitable.
Yes, Your Honor, and I'm making this argument because I'm responding to an argument that was made in the reply brief. We adumbrated it in a more limited way in footnote 119 to our brief, in which we say that it's doubtful that there's substantial evidence in the record to support a finding of reasonableness and prudence. And indeed, having more thoroughly reviewed the record, and in particular having with great care looked at all of the record references that Bay State includes in its reply brief, as well as ones that are mentioned in its opening brief, it's clear to us that nowhere in the record did Bay State offer evidence or make an argument that these were indeed reasonably and prudently incurred. But if the court...
Let's focus on what the DPU did find.
Okay.
Are you now saying that the fact that it is inequitable is not a proper basis for them to have denied this, that they would have had to go on to find that the costs were not reasonable?
It is an entirely each of the bases that the department gave and that we argue in our brief are independently sufficient reasons. It's just in the first instance that, having argued them on paper, I wanted to spend time developing this response. With respect to the reasons that the department gave, I'll say candidly that there's also some concern on our part that the court may conclude that the exposition of those reasons might have been more thorough. And in that event, I want to be very clear that the result should not be an award of these never justified costs to Bay State as increased rates, but at worst, from our point of view, a remand for a more thorough exposition of the department's reasons. Having said that, I think that it is reasonable to say, may I conclude just this one thought, Your Honor? It is reasonable to say that when the department, when they say that these same issues are going to be available for review in the Section 94 proceeding, that it means the issues that would have been considered in the Section 96 proceeding, and in the Section 96 proceeding, the question would have been no net harm. That's one of the same issues that was expressly reserved by the department in this case. Thank you, Your Honor.
Thank you.
All rise. All persons having anything further to do before the Honorable